Lord, I beg to mention item 11, my lord. Lord, I pray that I may be permitted to withdraw this writ petition, my lord. Item 11, my lord. The bonded matters. Bonded warehouse.
Okay. Mr. P. Nungvi, Learned Counsel is paying to the petitioner. On instruction submits that petitioner would not like to press this petition and prays for permission to withdraw this. This paragraph on prayer being made. And on prayer being made, the petition stands dismissed on withdrawal.
Deeply obliged.
May I please, Your Lordship, I beg to mention item number 9. Your Lordship, the conducting counsel is on legs.
Yes.
The conducting counsel is on legs, Your Lordship.
So, the matter is not yet called. The matter is yet to be called. Can be a ground for adjournment at the mention hour.
Yes, Your Lordship. Okay, let the matter come up, Your Lordship. Let the matter come up, Your Lordship.
Yes.
This is a matter related to that diversion of the funds from SPB. So, anyway, we have no objection. But
When shall we have it? After a week?
a week,
After 2 weeks, Your Lordship.
After 2 weeks. After 2 weeks. On prayer made on behalf of the state respondent. On prayer made by MS So-and-so, Honored G on behalf of the state respondent. The matter stands adjourned. List after 2 weeks.
mature.
I beg to mention item number 21.
Yes.
Yes, Lordship, this is quashing matter, so it may come up after 3 weeks, Lordship.
Yes.
Connected. with the-
Probably there was a matter yesterday
Yes,
in the division bench. And then in a criminal appeal, the similar ground was raised. I think this matter probably will be listed along with that other matter which has been referred. Recently, probably date would be fixed by the materials. Anyway, just say one prayer made by Mr. S.T. Upadhyay, Learned Counsel of the petitioner, list after 3 weeks.
My lord, item number 22, my lord, on joint
Joint
request, my lord.
request, Lordship. On joint
I
petition.
have sought for some instruction from the police department.
And John prayer made by the bodies. When do you want it?
After 2 weeks, no? Deputy.
Lordship, I beg to mention item number 18, Lordship. Lordship, here I am praying for 2 weeks' time, Lordship.
No objection of also. 18 2 weeks on the prayer made on behalf of the petitioner. Yes.
Obliged, Lordship.
Supplementary causes, item number 1.
Yes, Mr. Mahanta.
Maybe please, Your Lordship, this is a review petition because Your Lordship then mediation. The Lordship was pleased to dispose of the 2 cases. In fact, that time I was on leave when the mediation took place. Yes. Now it came to the notice of the review petitioner that the sub-engineer signed as a that CEO should have signed. There's a technical drawback came up.
You can correct it.
No, therefore it can be sent back to the again mediation. Then that can be
Mediation has been done. Where is the question of sending it back again?
because.
It is
That-
only what you say, it is only technical. in
Technical,
nature. You can
technical.
correct it. Execute a fresh agreement in terms of the same thing. It is not required. The order is also not required to be recalled for that. You do not need. If you find that there
No,
is some.
because Your Lordship, what has happened under the Act,
Yes.
he was not authorized to sign.
So
sub-engineer.
what is the Act
Section 49,
Yes.
if you're pleased to see the Mediation Act 2023, Section 49, Your Lordship, it has to be by written consent, written authority. He was not given a written authority. That is the drawback, Your Lordship. Your Lordship, here, Section 49. So, in some other cases, so similar
Section
things happen,
40?
Your Lordship.
49.
49. Invalidate the agreement as unauthorized action can be subject to legal scrutiny.
You know, even it's also not very convincing. And you will just issue notice, you will just say
Yes,
whatever.
that is possible. Yes.
And then
In fact,
even you see, you cannot take this plea, you see, in review. This cannot be a ground for review.
still the track means otherwise it will invalidate the agreement. That's what some other you also.
Where is the order of this court?
Order of this court is page 15, Your Lordship. Relevant portion 18, page 18, Your Lordship.
You are present. Your presence is recorded.
Yes, no, in this High Court is a record, but mediation,
Mediation, you are not.
that part
needed
actually
once.
the chief executive officer should have signed. Sub-engineer is not authorized.
But then this cannot be ground for recalling this order.
No, not, I'm not, actually,
So
just for,
review is only for this, nothing else. So order doesn't suffer from any.
no, order doesn't suffer, only that agreement.
Then your remedy may be somewhere else.
No, I can approach this court also, Your Lordship.
What for? This cannot be. See, where is the ground for review here?
Ground for review that technicalities crop up there.
That is okay, but then that is cannot be ground for review.
In the
Cannot be
mediation agreement,
No,
because the,
review, the ground is strictly guided by the provision of Order 47, isn't it?
let a notice be issued at this present. I'll try to satisfy.
Yes.
Lordship, we're accepting notice for respondents number 3 to 9, Lordship.
So it's for the union, in fact.
Lordship,
And who are the parties, other parties? Had Mr. S.P. Montul, Honored Senior Counsel,
private respondents, Lordship.
assisted by so and so. No. Issue notice. Returnable in 3 weeks. MS Sobral, Honored Counsel, accept notice on behalf of
Lordship, respondents number 3 to 9.
so 3 to 9.
3 to 9.
Union respondents, Lordship.
Okay. Step. The petitioner shall take steps for service of notice upon response number 1 and 2 within 2 days. List after
I
3
should send
weeks.
notice to 1 and 2.
Yes. You will take steps
I'll take steps.
in 2 days. List after 3 weeks. First issue notice returnable in 3 weeks. Yes.
Deeply obliged.
Daily cause list, item number 1.
Hearing for the petitioner in this matter.
Yes. Yes, please. Yes.
Lordship, I pray that the matter be listed at the end of board. Lordship, senior counsel is on legs.
Again, on the end of the board.
Lordship.
On the last occasion also you had problem. Yes, madam. What is to be done?
Yes,
At the
my
end-
lords.
At the end of the board.
At the end of the board, my lords.
Yes. Okay. At the end of the board. Okay.
Item number 2.
Yes.
Your Lordship, the connected matter is pending before the division bench.
Yes, Mr. Abram. Yes, ma'am. So when shall you have it again?
2 weeks' time.
Within 2 weeks, when this division bench matter is likely to be taken up?
4th of November, my lord.
Any day after 4th of November, Your Lordship.
So it will be after 3 weeks then.
Yes, sir.
Just see these things. I'll see the last order. Yes, just repeat the last order. 3 weeks. Yes.
Item number 3.
May it please your lordship?
Yes.
Your lordship, in this matter, I pray your lordship that I may be able to take time to seek instruction from the petitioner, my lord. On the last date also, my lord has granted me time, but
What
my
is
lord...
this matter about? Yes. Yes.
Lordship, this is an ACP MACP matter, Lordship.
Who is for the petitioner?
Mr. Jha, Lordship.
None appears for the petitioner. MS Suva is present on behalf of the respondent. List after a week. After 2 weeks.
6,
Right, Lordship.
Yes.
Your Lordship, I'm praying for 2 weeks' time.
You are appearing for?
Respondent number 5 and 6.
I'm for the petitioner, Lordship. Item number 6 and 7 are connected matter, Lordship.
There
are three items listed 8 also.
5, 6, 7. No, no,
6,
6,
7,
7, 8.
Yes. So if one is adjourned, all will be adjourned. So your prayer is in which case?
I am for number 7.
6, Your Lordship.
6.
6, who is petitioner? Yes.
I'm for the petitioner, Lordship.
You have no objection.
I have no objection, Lordship. 6 and 7, Lordship. I'm for the 6 and 7.
You are there in 7 also?
I am for the school, my lord, private respondent.
In item number 7, sorry,
7.
Zarika is appearing in item number 7.
Yes, all right, but then what is to be done here? Can it be like that one matter is adjourned and other is taken up?
This is connected, Lordship.
So what is to be done?
Then, because if the item number 6 goes, then item number 7 also, 7 and 8 also.
All right. On prayer made by the parties. This is met after 2 weeks.
Yes, Your Lordship.
All 3, 6, 7, 8. Yes.
Much Your Lordship.
item number 10,
Yes.
Lordship, this case is with regard to the EPFO's EPFO.
You are appearing for?
I am for EPFO,
For the respondent.
for the respondent.
Who is for the petitioner?
So Paul's chamber. Lordship, here it is so happened that the matter it is to be reverted to the CJIT because under 7I what I have mentioned and Lordship also has.
There is alternative remedy.
Yes, Lordship, and
Yes.
My lord,
we are supposed to take instruction, Lordship.
no, my lord, we will need to satisfy your lordship on that very point. That whether there is an alternative remedy, my lord, in view of the given circumstances, whether that exception can be waived or not. My lord, she has relied on a certain my lord, apex court judgment passed very recently. Your lordship had directed us to.
Another judgment has come. Maybe yesterday or day before yesterday.
Yes, Lordship. Same, day before yesterday, Lordship.
When there's a alternate remedy before the tribunal, my lord.
Lordship had.
But again, the exceptions are, even in that particular judgment also, my lord, the exceptions are carved out.
So let us see whether your case falls under exception or not.
No, that's the only area, my lord, I have to satisfy your lordship.
No. Then only we will go to the merit of the case.
Correct. Well, otherwise, my lord, the facts would. Well, I have to satisfy your lordship on the facts that the given facts falls within the exception that has been laid down in those two judgments, my lord.
What are the exception?
My lord, one is that but if they exceed jurisdiction. The other one is, my lord, if
Or is it something
is
like that
against
they assume
some-
some jurisdiction which is not vested in them?
right. And of course,
It is
my
not
lord,
a case that you are saying that they have no jurisdiction.
no, they don't say so, my lord. And the other one is, my lord, of course, the violation of
So
principle
that
of
will be a
law.
case of improper exercise of jurisdiction.
Right.
That will not come under the category of exception.
I
Anyway,
have to.
you just-
I'm only seeking some accommodation today, my lord.
Yes.
Lordship.
We can have it
is
next
a-
week, my lord.
Lordship, it's a long pending matter, Lordship, on the same ground, Lordship.
Any interim order here?
There's no
Lordship.
interim order, my
There
lord.
is
In
no
fact, they have already deducted whatever they could, and I think, my lord, the liabilities have already been settled.
There is no interim order. But Lordship,
It will not be possible after a week. It has to go after 2 weeks then.
Lordship.
After 1 week.
As
Okay. After 1 week will be possible. We'll have it after 1 week.
1 week.
1 week, Lordship.
Okay, on prayer made by Mr. Tapal under counsel for the petitioner. This is matter. After 1 week.
All right.
Item number 12.
Yes. Yes.
About the annexures enclosed to the FIR. That has not yet been
This
filed.
is in connection, if I may just point out, this is in the same FIR which has, or your lordship has been pleased to reserve orders in.
No, that is all right. But then,
Here, lordship, there were certain annexures in the FIR which were missing.
yes.
The complainant was to file an affidavit to bring that on record.
No, it was basically it was missing, but then it is respondent number 2 who undertook that he will.
He is the complainant.
Yes. Where?
Yes, Your Lordship.
Yes. Yes.
Your Lordship, actually, like, due to some family exigency, I was not able to do it, Your Lordship, but it will be filed during the course of the day, Your Lordship.
Okay. Yes, Mr. Pierre Pascal, Honored Counsel, appearing for the resolution number 2 submits that it will file today only. Are you sure?
Your Lordship, by Monday, definitely I'll get it filed. Your Lordship.
Then it's okay. Just say one prayer
Because
made by Mr.
if I just make a bold statement over here, Lordship, because
Okay.
it's
See,
already
one prayer made by Mr. Pascal, Honored Counsel, appearing for the resolution number 2. Further 1 week's time is granted for filing the additional affidavit in terms of the order dated 9/10/2025 of this court. List accordingly.
Obliged. Obliged, Lord.
deeply obliged.
15 is 15 is
Same-
connected,
same
Your
order.
Lordship.
Same
I'm
order.
appearing for the state here.
Yes, same order.
16.
15 you record. Dummy and case.
For the state.
Yes.
In item 16, Mr. Shilla is there, lordship, for the petitioner.
He's still not well.
He has joined, he had appeared in the High Court in, I think, Monday. I'm praying for a week's time, lordship.
Who is the other side? Yes.
I'm for the
What is
state
this?
respondent. This quashing, Your Lordship.
is-
Quashing of the
This is
criminal
settlement.
proceedings where the witnesses have already been examined. All the witnesses cited by the prosecution.
Your Lordship,
Yes.
for this matter, the conducting counsel is on his leg, Your Lordship.
Yes.
Lordship, then let it be next week. Mr. Keshav is appearing.
Okay. On prayer made on
Your
behalf of-
Lordship,
Everything is ready. I filed the affidavit also.
Your Lordship, let this matter be come up at the end of the court, Lordship.
Let it be next
There are,
week,
there are
Lordship.
many matters at the end of the board. That is that. That is
That in which the body was exhumed.
where there was no proper investigation.
Yes.
Your Lordship,
His prayer is to transfer the investigation. The IO has filed the FR, Lordship, in the court.
Yes.
My lord, they have filed the FR. My lord, that FR is what on record. My lord, we have worked through it. My lord. The investigation, my lord, I'll submit, was not done in a proper manner. Now, if I take my lord to the FR.
Now, this FR was accepted.
No, my lord.
Yes,
The
filed,
FR was
Just a minute. Just let us
was
let
filed
us
very
proceed.
recently.
It was filed, Lord.
So you will be given notice.
They'll be
You
given
object.
notice.
Make your objection there. Raise your objection there. That is what the law says.
Yes.
My lord, that is insofar as the FR is concerned. Now, my lord, we have filed this writ petition asking for constitution of a SIT for investigation into the matter, because we are not satisfied with the manner in which the investigation has been done.
That depends upon
My lord, we will satisfy this court.
acceptance or non-acceptance of FR, isn't it? Now say supposing we pass an order constituting a special team and their FR is accepted, then what happens?
My lord, that in my submission, my lord, that will not be a bar to entertain this petition, my lord.
What will not be a bar? We must avoid passing of conflicting order by the courts.
My lord, we have.
You can come with a prayer for constitution of a special investigation team.
My lord, if I may just submit, my lord. Now, my lord, what happened here was that this, my lord, is the second round of litigation, my lord. The petitioner was before this court on the earlier occasion with a petition under 482, my lord. In that petition, my lord, an affidavit was filed, wherein in that affidavit, my lord, the certain facts were brought. Now, my lord, at that time, the submission was made at the bar. The investigation is at the stage of completion, and very soon the whatever is the outcome of the investigation shall be placed before the court. However, that was not to be done, my lord. Subsequent thereto, we filed a petition under 156(3) before the Chief Judicial Magistrate in the concerned district. The CJM passed an order. After hearing us, the CJM passed an order directing that the investigation has to be conducted by a senior police officer, and periodic report of the investigation is to be submitted to the concerned court. That also was not done. That also was not done.
Order? This is there in the part of record.
Yes, yes.
Okay. Then what happens? Okay.
Now thereafter, my lord, we were compelled to file this petition. Now, after we filed this petition, my lord, notices were issued by this court. Then, at a later, while this petition was pending, an order was sought for from the CJM's court to exhume the body, and a fresh post-mortem report and a fresh autopsy was done. Meanwhile, in this writ petition, we have made the doctor also who had conducted the earlier post-mortem a party. Now, she filed the affidavit. The doctor files an affidavit saying that I have not conducted the post-mortem in a proper manner because somebody came and approached me saying that this matter is not going to be registered as a police case. Now, my lord, here in this case, initially the police had filed a UD report. The district police had filed a UD report. Now, subsequently, there is an affidavit before this court filed by the doctor saying that I did not conduct the post-mortem in the manner as is prescribed under the law because I was approached by somebody saying that this matter will not go to the police. Number 3, after this incident happened, some people had written to the deputy commissioner seeking for exemption of the post-mortem. It was not the family members. Some community members had written to the deputy commissioner for exemption of the post-mortem. That was not allowed. The post-mortem was done. Our case before my lord is that the post-mortem was done in a very casual manner. In the earlier post-mortem report, the cause of death has been the cause of death is as per the post-mortem report is asphyxia due to drowning. Now there is a subsequent post-mortem which talks about different types of injuries. Now in the FR also, whatever investigation they have conducted, my lord, after my lord's direction, a detailed report has been filed. Now after going through the report, we find that there is one person who has consistently been saying that this is not a case of accidental death. However, at a subsequent stage, that person has changed his statement. So, my lord, we had filed this petition. We filed this petition because
you can understand we are not
using
your matter, but then
investigation, my lord, the law says investigation should be such that will not shake, my lord, that will instill confidence. My lord, the manner in which the entire investigation has been done right from day one, my lord, the very confidence of the of the complainant on the investigating agency is shaken. And these are not mere submissions, my lord. There are affidavits on record. the doctor having, the first doctor who conducted the post-mortem having filed an affidavit stating that no, I did not conduct the post-mortem in a proper manner because I was approached by someone. Now the attempt of the police to hush the entire thing by filing
whatever
a
the
UD
thing,
report.
you see, you file your objection in that case. Now,
Yes,
now
of
if you
course,
have-
my lord. That is
you
a
do
separate proceeding in my humble submission, my
So
lord.
let
I will
us-
file it
let
there.
us- Let us wait for the outcome there. What happens?
All
there.
right, my lord. Let this matter.
Because we would not
kept-
like to pass any contradictory order. There should not be any contradiction. Should not be any confusion.
My lord, what I am submitting is, my lord, if tomorrow I file an objection there, if file an objection and my objection, my lord, if my objection is taken into consideration and the same police is asked to investigate, my
Then
lord.
we will see. Then we will see. Then we will see what is there. We will keep it pending. We are not
Yes, my lord.
disposing it.
Let this.
For the timing, we must avoid any kind of passing of
As
any
per the investigation, Lordship, it was an accidental death. He fell down from the top of the waterfall, Lordship.
My lord,
He slipped and fell down.
My lord, and what is also disturbing is in this case, my lord, this was a case, subsequent FIR was filed, FIR was registered under section 302 against a named accused, my lord. This named accused was never arrested. My lord, it is up to the police whether to arrest or
You
not.
see, you
But-
lost your complaint that also after
3 months.
lapse of 3 months.
Yes,
3
my
months.
lord.
That
My
is
lord,
what the problem is.
That is there. That is there.
That is
But
also-
however,
you also
my lord,
have
enough
not
opportunity was
suspected.
given.
You
Enough
see,
opportunity, my lord.
You have to take into consideration that whether, you see, any investigation by expert agency will serve any purpose or not. That also you have to consider. We will not ask for any investigation to be made just for the sake of satisfaction that investigation has been done. We have to see what is there. Anyway, you just pass this thing. Yes, submitted by Mr. Kharmi Lanak, additional PP, that an affidavit has been filed to bring on record the FR number 22 dated 22/9/2025 submitted in connection with the
Submitted in
William
connection
Nagar
with
case number?
William Nagar PS case number
24/5/2025.
of 2023 under section 302 I guess.
Mr. Yes, Gautam.
Lordship, this repetition has become infructuous now, Lordship.
We'll see. We'll see. Let us see.
Suppose that-
See, like we'll not close it as of now. We'll just see. We'll just see, because even if, say, supposing FR is accepted, he may have a remedy under law to challenge it. But then whether he can make a prayer for investigation by some other authority, that is what.
No, that I will satisfy,
So
my
that
lord.
is
That
is
you will
what
have
is
to
concerned. So that
show,
is what.
show that.
Anyway, just say Mr. Gautam Lanak Council should take necessary instruction. S2. But when this was submitted, it is.
Yeah, Lordship submitted on 22/9.
This is 22/9.
22/9. My lord, I have instructions that we have received notice
Okay.
from the magisterial court.
Okay. So that is better way then. That if you give us the actual and true information, that helps us in passing order. Just say, Mr. Gautam Lanak Counsel for the petitioner submits that the petitioner has received a notice of submission of the FR in the above case. And prays for grant of some time to obtain necessary instruction in this regard. Prayer the Lord, list after 2 weeks. You do
My
the
lord,
needful.
let it come after
there
4
first.
weeks, my lord. 2 weeks.
Okay. Now just stop then. Yes, as prayed for by the Lanak Council. Yes, for the petitioner, list after 4 weeks.
4 weeks.
Just see and see your remedy. If
My lord.
it is available there, then definitely just see. Just he explored the possibility.
For transferring the investigation, the law is there,
My lord,
laid
of
down
course,
by
my lord,
Supreme Court.
I am aware of that
The
law,
law
my lord.
there.
Puja Pal is there.
There are many numerous decisions, Lord.
Numerous decisions, my lord. And all decisions, in unison, they say only one thing.
Who transfers? Who has the authority to transfer?
My lord, the High Court. In exercise of powers under 226, in exercise of powers under 482.
Discretion is there in the High Court, but there
power is there
are
in the High Court.
criteria and factors, many factors.
Okay, we will deal with all those
Yeah.
rules when
Lordship. Obliged, Lordship.
19.
Obliged.
yes.
May please, Your Lordship. Your Lordship, this is an appeal to quash and set aside the FIR dated 16/6/2017 proceedings in GR case number 112 of 2019 and order dated 19/3/2025 passed by the Judicial Magistrate First Class at Law. Your Lordship, on the last occasion, Your Lordship, this Honourable Court, Your Lordship has raised a question, Your Lordship, whether 482 is maintainable, though there are alternative remedy, Your Lordship. Your Lordship, to this, Lordship, I have one judgment with me, Your Lordship.
Prabhu Chawla.
Yes, Your Lordship. May I read the operative part, Your Lordship? That is in para 2, Your Lordship. First, we take up appeals of Prabhu Chawla and Judges Upay Sani and others, as these two criminal appeals seek to assail a common order dated 2/4.
Yes. Prabhu Chawla is a decision by 3 judge bench because there are conflicting between decision by 2 different benches. So it was referred to
Yes, Lordship.
to this. And
Your
then
Lordship, ordered in para 2, Lordship, that is order 2/4/2009, Your Lordship.
Yes.
The High Court, Lordship, has set aside stated that the petition to be not maintainable in view of the judgment of Rajasthan High Court in the case of Sanjay Bahadari versus State of Rajasthan, holding that availability of remedy under section 397 CRPC. Your Lordship, if we come to para 8, Your Lordship. Para 8, Lordship, on the last part, Your Lordship. The impugned common order dated 2/4/2009 passed by the High Court of Rajasthan is set aside and the matter are remanded back to the High Court for fresh hearing of the petition under section 482 of the CRPC in the light of law explained above and for disposal in accordance with law. Since the matter have remained pending for long, the High Court is requested to hear and decided the matters expeditiously, preferably within 6 months. Your Lordship, we can see that 482 is maintainable.
where it stands now means then 397 can be ignored, it means CRPC. And all petition can be filed under 482 by ignoring the provision of 397, isn't it? Is this the position of law now?
Your Lordship, we have come before this honourable court with 482, Lordship, to quash the FIR, the criminal proceedings, and the order passed by the Judicial Magistrate.
Yes. What is your point? You want to say anything on the... No, anything on this issue?
Complete.
Okay. Please.
Your Lordship, before coming to the merits of the case, Lordship, I will challenge the maintainability of the jurisdiction, the jurisdiction of the CBI, Your Lordship. The power and jurisdiction of the CBI. Your Lordship, the brief of the case, Lordship, that an FIR was filed against the petitioner, Your Lordship. Your Lordship, the FIR is at page 241, Your Lordship.
Who is a petitioner? What is his occupation? What is?
Your Lordship, he is a contractor, Your Lordship.
He's a businessman.
Yes.
He's a contractor. Okay.
May I read the FIR, Your Lordship?
Yes, yes.
On receipt of information from
Where is the FIR?
page 241, Your
So
Lordship.
you say that fast. Yes.
On receipt of information from reliable source alleging serious defects in the execution of works by the accused contractor AO4 against the contract excavation of trenches and laying of OFC through duct, etc. in 62 Gram Panchayats villages of Moplang Block, East Khasi Hills, Meghalaya, awarded by Ratel Corporation of India, Vibe Letter of Acceptance, LOA number Ratel Tender OTERHQ 2014 to 15 724-348, dated 11/04/2015, and amended LOA dated 26/07/2016 for contract value total amounting of rupees 3 crores 82 lakhs 14,940.88. Joint physical inspection were carried out with effect from 12/12/2016 to 15/12/2016 in 18 Gram Panchayats villages by a team of officers of CBI Shillong branch to confirm the alleged defects in the presence of the officer of Ratel Shillong, including the site engineer of Ratel and the contractor and other independent witnesses, and a memorandum was drawn mentioning the findings of the joint physical inspection. Copy of the said memorandum is enclosed herewith. The joint physical inspection disclosed that the accused contractor had shown excavation of 14.113 kilometers trenches in respect of 16 villages as chase cutting in rocky area, and claim at the full approved rate of chase cutting at rupees 2,54,829.01 per kilometers, total amounting to rupees 35,96,401.82, though the actual excavated soil at site were found to be of soft soil, which is payable at rupees 64,141.10 per kilometers, taking the depth of the excavated trenches at 0.90 meters to 1.19 meters, and hence an excess amount of rupees 26,34,726.47 had been claimed.
You are A4. You are A4.
Yes, yes.
Contractor. Accused
Yes,
contractor. Yes. All right. Carry on.
Had been claimed fraudulently and dishonestly by the accused contractor A4 on the basis of false entries in the site register MBS and by the accused officer of Ratel A1, A2 and A3 as a result of their criminal conspiracy. The joint physical inspection also disclosed that the actual excavated depth of the trenches at site was at average of 0.7885 meters with minimum depth of 0.17 meters and maximum depth of 1.60 meters, which is payable at rupees 68,141.10 per kilometers, and hence total amount payable against 6.294 kilometers comes to rupees 4,28,880.09. However, the accused contractor in criminal conspiracy with the accused officer of Ratel had claimed at the approved full rate of rupees 1,36,282.20 per kilometers against 6.294 kilometers, showing depth of 1.65 meters. Total amount of rupees 8,57,760.17, and hence amounting to rupees, and hence an excess amount of rupees 4,28,880.08 had been claimed fraudulently and dishonestly by the accused contractor on the basis of the false entries in the site register MBS by the accused officer of retail. During the joint physical inspection, it was also noticed that the accused officer of retail had maintained the site register in a perfunctory manner without mentioning the chainage of different depths of trenches excavated sites, indicating that the accused officer of retail had not physically made the measurement at site but mentioned different depths including chase cutting at their own whims and fancy in criminal conspiracy with the accused contractor. It is also alleged that no such chase cutting was done in other villages of Moplang block against the contract work in question by the accused contractor in criminal conspiracy with the accused officer of retail against the aforesaid excess amount claimed by the contractor, total amounting to rupees 30 lakhs 63,606.55. Retail Corporation of India had so far paid 50% of the claim amount, and hence the excess amount paid so far to the accused contractor comes to rupees 15 lakhs 31,803.28, which is a lost cause to Retail Corporation of India. Hence, the joint physical inspection carried out in the said 18 villages of Maupang block prima facie established that the accused officer of retail Shillong, namely Shanbor Kharkungor, Joint General Manager Shri Subarta Bhomeg A2, Senior Manager, and Shri Kitborlang Purba A3, Project Engineer in charge of Maupang block in criminal conspiracy with each other and also with the accused contractor Shri Reno Nongset and unknown others abused their official powers, position, and fraudulently and dishonestly had falsely shown excavation of trenches at higher depth in the site register MBS as against the actual depth excavated at site, and also falsely show chase cutting in rocky area for substantial length, though the actual soil at site are soft soil and thereby cause wrongful loss to Retail Corporation of India to the tune of rupees 15 lakhs 31,803.28 and corresponding wrongful gain to themselves to that extent that the aforesaid facts prima facie discloses commission of offences punishable under 120B, 420 IPC and Section 13(2), read with 13(1)D of PC Act 1988 on the part of the accused Sri Shanbor Kharkungor A1, Joint General Manager, Retail Corporation of India, Shillong, Meghalaya, Sri Subarta Bhomeg A2, Senior Manager, Retail Corporation of India, Sri Kitborlang Korba A3, Project Engineer in charge, Mauplang Block, Meghalaya, Retail Corporation of India, Contractual, Shillong, Meghalaya, the contractor Sri Renol Nongset A4 and unknown others. Hence, a regular case is registered against accused person Sri Shanbor Kharkungor A1, Joint General Manager, Retail Corporation of India, Shillong, Sri Subarta Bhomeg A2, Senior Manager, Retail Corporation of India, Shillong, Sri Kitborlang Korba A3, Project Engineer in charge, Mauplang Block, Retail Corporation of India, Shillong, Contractual, the accused contractor Sri Renol Nongsen A4 and unknown others, and endorsed to Sri Kayusheng Bharali, Inspector, CBI ACB, Shillong Branch for investigation. Thereafter, Your Lordship, the matter was forwarded for investigation, Your Lordship, and it has been charge sheeted, Your Lordship. The charge sheet is at annexure 1, Your Lordship, page 246, annexure 16 246. Your Lordship, we can see that in the charge sheet, Your Lordship, the section, Your Lordship, under PC Act were dropped, Your Lordship, and the section remain are only 120B, 420 and 511 of the IPC, Your Lordship.
Page 246.
Yes, Your Lordship. Annexure 16. Thereafter, Your Lordship, we had filed an application, Your Lordship, under section 239, Your Lordship, CRPC, praying for discharge of the accused person, Your Lordship. However,
Now, this PCF is dropped, other accused also is dropped. You are the only person against whom charge sheet is filed.
two accused, Your Lordship. Two accused.
You and who else?
Kitbor Lang, Your Lordship.
He is a government servant.
No, Your Lordship. He is defined as an outsourced, Your Lordship. He's an outsourced, Your Lordship.
But then who contacted him? You gave him.
Yes, Your Lordship.
He was under you.
Yes, Your Lordship.
You appointed him.
Yes, Your Lordship.
Okay. So against you, so it means he is under you only.
Yes, Your Lordship. He's an outsourced, Your Lordship.
He is a project engineer, my lord. Lordship will find that at page 247.
Project engineer. So he is your employee. Oh, sorry,
Right.
this is the employee of the
Railtel Corporation.
But then that is this thing, a private body.
Railtel is a railway department corporation.
It's under government.
Well, page 247, Lordship,
yes, occupation, project
engineer outsourced from so and so, Railtel Corporation of India Limited, Shillong.
Okay. Okay. Yes. All right. But then this PCA Prevention of Corruption Act was dropped. But then he fact remains that he is a public officer.
Yes.
Yes. Okay. Then what happened? So he is not an outsourced person.
He's an outsourced person.
How do you say? Because chart sheet shows that
From
he's.
his charge sheet, Your Lordship.
He outsourced from some company, but he is working under the.
Oh, see, outsourced from Genesis International.
But he is working for Railtel Corporation of India.
But then he was discharging public duty.
Yes, ma'am. Of Railtel.
Okay. Okay. All right. So he is outsourced, but they're not appointed by the petitioner.
No, madam. It is
unconnected to the petitioner. He is unconnected to the petitioner.
Yes. Yes.
Your Lordship, may I submit this, Your Lordship?
What is this? If you are giving something which is not a part of record, then you have to supply it to the other side also, and we have to see the admissibility of this.
Your Lordship.
Yes. Prosecution sanction.
Yes, Your Lordship. He's a project engineer outsourced working in Meghalaya, Your Lordship.
No, but then it's okay. Once his sanction has been accorded, that means he falls under the category of the government servant, isn't it?
But Your Lordship, he doesn't hold any office, Your Lordship. And he doesn't come under the...
What for you have given this? What you want to show it?
To show that he is an outsourced, Your Lordship.
Okay, Railtel cannot take any action in this regard. Dr. Mojik, I have seen that. Anyway, it's okay. We are not concerned with him. If he is unconnected with the petitioner. Yes.
Thereafter, Your Lordship, we had filed an application, Your Lordship, during pendency of the case, Your Lordship, we had filed an application praying for discharge, Your Lordship, under section 239 CRPC. However, Your Lordship, the Judicial Magistrate First Class has rejected our prayer, Your Lordship. The operative part, Your Lordship, is at page 320, Your Lordship, of the application, Your Lordship.
It starts from which page? Impugned order? This order is impugned here.
Yes, yes.
What is the order? Order dated?
Annexure 21. Annexure 21, page 341.
What is the date of the order?
19/3/2025.
Annexure?
Annexure 21.
Page?
341.
And what is the operative part?
Mayor, Your Lordship, paragraph 43, Your Lordship, page 350.
Yes.
May I read, Your Lordship?
Yes, yes.
Section 239 CRPC provides that if upon considering...
You are reading conclusion.
Yes, Your
Yes.
Lordship. Upon considering the police report and the documents sent under Section 173 and making such examination if any of the accused as the magistrate thinks necessary, and after giving the prosecution and the accused opportunity of being heard, the magistrate considers the charge against the accused to be groundless, he shall discharge the accused and record reason for his doing so. Here, for the reasons discussed above, the charge against both the accused persons are not groundless, and if the assertions of the prosecution is to be taken at face value, there is a strong suspicion against the accused persons. Therefore, the application for discharge filed by the accused number 1 and accused number 2 does not succeed. There is sufficient basis to proceed to frame charge again under Section 420 IPC and 120B IPC as against Raylon Nongsit, and to frame charge again under Section 120B IPC and in the alternative Section 107 IPC as against Kitborlang Purba. Your Lordship, we can see that the allegation made against the petitioner are under Section 120B and 420 of the IPC.
And what is in the alternative means? What does it mean? And in the alternative?
Section 107 IPC as against Kitborlang Purba.
Okay. This is only against Kirborba's.
Yes.
So why it is in the alternative? Okay. Okay. Yes.
Your Lordship, before going to the merits of the case, Your Lordship, I would like to challenge the power and jurisdiction of the CBI, Your Lordship. Your Lordship, we can see that in the FIR, PC Act is mentioned, Your Lordship. However, Your Lordship, in the charge sheet and in the framing of charges, Your Lordship, the PC Act was dropped, Your Lordship. Your Lordship, we can see that the CBI doesn't have any jurisdiction, Your Lordship. And to this, Your Lordship, I would also like to support my submission, Lordship, in the case of Shri P. Patha, Your Lordship, passed by this Honorable High Court, Your Lordship. May I read, Your Lordship, para 25, Lordship?
This is a decision by coordinate bench.
Yes, Your Lordship.
Para?
Para 25.
Yes.
However, under Section 6 of the said DSPE Act, if the CBI is to be operate in any state concern of such state government for exercise of its power and jurisdiction is required. By now, it is well settled that the CBI can investigate into cases involving offences under the PC Act. However, when it comes to offences under the IPC, which are generally taken up and investigated into by the state or local police, if a particular case involves provisions of offences under the PC Act as well as IPC, then the CBI would be well within its right to investigate into such cases. But if, as in the present case, though initially the offences involve provision under the PC Act along with those under the IPC, which was rightfully investigated into by the CBI after the filing of the charge sheet, wherein only the provision under the IPC remains, which the offences under the provision of the PC Act were dropped, including release of liabilities of the public servant, implicates therein, it stands to reason that the jurisdiction of the CBI would cease as on the date of filing of the charge sheet. At this juncture, if the CBI is to
What is meant is that the CBI would cease. Stands to reason that the CBI jurisdiction of CBI would cease as on the date of filing of the charge sheet. That is mean what it would mean. That will invalidate the charge sheet, or what would be the exact meaning to be gathered from here?
would cease, Your Lordship. The CBI jurisdiction of the
As on
CBI
the
would
date of
cease.
filing of the charge sheet. That means the investigation conducted so long, what would happen to those? I mean, like, what would be the status?
Cease, cease, Your Lordship.
This see, it is not. It says seize. Would seize as on the date of filing of the charge sheet. That means what? Anyway, Dr. Mojika was there. He will explain us.
Well, may I just answer, because it will not be necessary to go into this judgment, my lord. We filed SLP against this, my lord.
Yes.
The Honorable Supreme Court said that we do not find any ground to interfere with the impugned order passed by the High Court. However, question of law is left open. So all these issues,
See, Supreme Court did not find any ground to interfere.
Interfere with the judgment, but the Supreme Court
So
said
in
that
that view of the
question of law
matter
is left
also,
open.
see, the judgment of the coordinated bench will not have binding effect.
It says a question of law is left open, my lord.
Anyway, this is something we do not know. Anyway, we'll just come to you since you were there in that case, so you can explain us better. Let us hear. Anyway, it's okay. So what? Anyway, just to complete the reading, then we'll ask you a question. Yes, ma'am.
Your Lordship, I'll continue with the reading.
Yes, please. At this juncture, the CBI is to continue prosecution. Yes.
Admittedly, nothing is on record as to whether such consent was given or not, or whether the same was requested or not. In view thereof, as submitted by the learned counsel of the petitioner, that the charge sheet was forwarded by the CBI in the court of the Chief Judicial Magistrate, the same was without jurisdiction. On this ground alone, the entire proceeding against the petitioner are vitiated. As to the contentions of the learned counsel for the petitioner, that even
means,
otherwise...
just hold a minute. It means, this finding was that since the jurisdiction of CBI ceased, so to prosecute the accused, there is a need of specific sanction. Was it specific consent of the state?
Your Lordship, as stated in para 25, Lordship, there is section 6, Your Lordship, of the Delhi Special Police Establishment Act, Your Lordship, 1946. May I read, Your Lordship?
Yes.
Page 5, Your Lordship, section 6. Consent of the state government to exercise of powers and jurisdiction. Nothing contained in section 5 shall be deemed to enable any member of Delhi Special Police Establishment to exercise powers and jurisdiction in any area in a state or being a union territory or railway area without the consent of the government of that state. Your Lordship, Your Lordship, there is a notification, Your Lordship, to this, Your Lordship, page 322, Your Lordship.
Yes.
Annexure 17, Your Lordship.
Yes.
May I read, Lordship?
Yes.
In pursuance of the provisions of Section 6, the Delhi Special Police Establishment Act 1946, Act number 25 of 1946, the Governor of Meghalaya hereby occurs consent on the extension of powers and jurisdiction of all members of the Delhi Special Police Establishment to the state of Meghalaya for investigation of offences as indicated hereunder. A. Offences under the Prevention of Corruption Act 1988, Act number 49 of 1986. B. Attempt, abetments and conspiracies in relation to or in connection with one or more of the offences mentioned above, and any other offence or offences committed in the course of the same transaction arising out of the same act. Your Lordship, we can see, Your Lordship, that the CBI can entertain the case only if there is PC Act, Lordship, if there is a relationship to or in connection with one or more of the offences mentioned in the Prevention of Corruption Act. Your Lordship, in this instant case, Lordship, we can see that nothing on record to show that the CBI have got or received consent from the state. Your Lordship, we can see that the role of the CBI in filing the charge sheet is questionable, as no offences under the Prevention of Corruption Act has been made out.
So since there is no allegation against under PC Act,
Lordship, the CBI has no locus, Lordship, to as the locus of the CBI is questionable, Your Lordship, as complainant.
now investigation of offence. Anyway, now
That also CBI, na? Supplementary list.
according to you,
Some grounds.
since there is no charge found under PC Act, so CBI had no authority to investigate the matter.
Yes, Lordship. It's very clear, Lordship, in the notification, Lordship.
Yes. But then what does it say? See the second line of B. And any other offences or offences committed in the course of the same transaction arising out of the same facts.
By Lordship, there must be in relation to or in connection with one or more of the offences mentioned above, Your Lordship.
No, see the same transaction. Just see. Attempt, abetment, relation to the connection with the offences mentioned above, and any other offences or offences committed in the course of the same transaction arising out of the same facts. Now, in the course of the same transaction, it says. Now, just because there is no charge against under you and PC Act, it cannot be said that the transaction becomes a different one, isn't it? The transaction remains the same.
But my Lord, there must be a relationship or in connection, Your Lordship. Even if there is a transaction, there must be.
Okay. Yes. Okay. Yes.
And Your Lordship, if we come to the merits of the case, Your Lordship.
Merit.
Yes. Lordship, we can see that the allegation made against the accused person, Lordship, is under section 120B and 420 of the IPC, Lordship. If we come to section 420, Lordship, that is cheating and dishonestly inducing delivery of property, Lordship.
Yes.
May I read, Lordship? 420, Lordship.
Yes, yes, please.
Whoever cheat and thereby dishonestly induces the person deceived to deliver any property to any person or to make, alter, or destroy the whole or any part of a valuable security or anything which is signed or sealed, which is capable of being converted into a valuable security, shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine.
Yes.
Your Lordship, if we come to the ingredients of offences under 420, that is cheating, Lordship. Cheating, if we come to section 415, Lordship, which defines cheating, Lordship. Whoever by deceiving any person fraudulently or dishonestly induces the person so deceived to deliver any property to any person or to the consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to the person in body, mind, reputation, or property, is said to cheat. If you come to the first ingredient, that is by deceiving any person, Lordship.
So what do you want to say?
Lordship, there's no deception, Your Lordship. The petitioner did not deceive, Your Lordship.
No, you have claimed false bills. You have enlarged the work. You have shown that this work was enlarged, and then thereafter you received the money.
If we come to page 15, Your Lordship, it's very 213, Your Lordship.
Yes. 213 is what?
It's the first variation, Your Lordship.
What is 213?
Lordship, 213, Lordship, is the statement of the first variation, Your Lordship.
No, why should we go into all those things? We will not go. The FIR is good enough. This will be revealed at the time of evidence is taken, so far as the merit is concerned. But then your other points remains to be there. The jurisdiction of CBI.
Your Lordship,
You
other
see,
than
the FIR says that you have done work of lesser volume, and you have showed that you have done work of a higher volume and thereby escalated your bill and defrauded the state. So that amounts to 420 only, nothing else. That way you cannot say that ingredients of 420 is not available.
And Your Lordship, is pertinent to mention, Lordship, that the amount has been recovered, Your Lordship, by the greater, Your Lordship.
Does it wash away your crime?
And it's part of the contract, Your Lordship. It's part of the greater, Your Lordship, part of the contract, Your Lordship.
What is the part? What is part of a contract? The refund of loss.
Yes, Your Lordship.
So there is a clause provided there.
It should be of civil. It should be of civil dispute, Your Lordship, not criminal.
No, that is all right. Here it's a question of self. It's a question of deceiving. You see, you have done a small work. You say I have done a big work. and then you escalate your big and get that money. So later on inspection, it is found that no, your work you have done is very small. So prima facie FIR definitely has some materials, isn't it? Anyway, it's all right. Your submission remains. So you are charged under 420 and 120B.
Yes, Your Lordship.
So you say that there is no ingredients of 420 IPC, isn't it?
Yes, Your Lordship.
And then what else you want to say? Now, this 120B, conspiracy. Now, what is the allegation? You have conspired with whom? Is that project manager?
Yes,
And was he a man who was liable to give you contract? What was the job of the project manager? Now, if that 120B is to come into play in such a case, what is the allegation? You have entered into conspiracy with whom?
with the other accused, Your Lordship.
Others are dropped. Only two are out of the 4 or 5. All others dropped. There are some government servants, isn't it? There were some government servants, so far as the FIR is called. FIR is, so far as the FIR is concerned, it contained 5 names, 4 or 5 names, isn't it? But then charge sheet is filed against only 2%.
Yes, Your Lordship.
So those all other government servants, I think those 3 others were government servants.
One, Your Lordship.
Out of the 5 persons in the FIR, how many were government servants?
One, Your Lordship.
Who was that? A accused? He has been charged sheeted or not?
No, Your Lordship.
He has not been charged sheeted. And now then the allegation of conspiracy is with whom? You have conspired with whom?
With the engineer, Your Lordship. He is an outsourced.
The remaining accused.
Yes, Your Lordship.
And what role he had in the department? What was his work?
He's a project engineer, Your Lordship.
No, and so far as your work is concerned, what specific role he played there?
To record.
What role he had in passing and disbursing the bill claimed by you? What role he had? Any idea? Do you have any idea?
Passing to record the his role is just to pass the bill, Your Lordship. He has no role.
No, but then you said that he was a outsourced man. He was basically an outsider. So how could he be instrumental in passing the bills? Is there any specific allegation in the FIR saying that you have conspired with that particular accused? His accused number, A number? You are accused 4. And
A4.
And the other person is? This project engineer is A3. A3. Now, any specific allegation in the FIR saying that you have conspired with A3?
No, Your Lordship.
Are you sure?
Just vaguely that in the FIR, just vaguely that stated that there is criminal conspiracy between A4 and A3, Your Lordship.
It is stated there or no?
If you come back to the FIR, Your Lordship.
So there is allegation in the FIR. Okay, so that is what the court is asking you. So there is a allegation of criminal conspiracy between A3 and A4. Okay, what else you want to say? Anything more?
Your Lordship, if there was any dispute, Your Lordship, between the petitioner and retail, Your Lordship, it will be civil dispute, Your Lordship, since retail have issued, Lordship, have issued conditions, Your Lordship, regarding with regard to the contractor, Your Lordship. That is an extra one, Your Lordship.
Annexure 1, page. What is the page? Yes, page 21. Yes. And what do you want to show in Annexure 1?
One three four, Your Lordship.
134, page 134.
Yes, Lordship.
It's a part of Annexure 1.
Yes,
It's a continuation.
Yes, Lordship.
Yes.
Your Lordship, if we come to point 5.490.
Settlement of
Yes,
dispute and arbitration.
and arbitration, Lordship.
Yes. No, dispute has to be raised, isn't it?
Yes, Your Lordship. If there is any dispute, Lordship, it would be of civil nature, Your Lordship.
No, but then this has to be invoked, isn't it? Merely there is a presence of a clause, arbitration clause.
But the contract work is per the retail, Your Lordship, is per the conditions and the provision of this retail book, Your Lordship. And moreover, Your Lordship, the work has already been completed, Your Lordship.
And then what you said you refunded money.
Yes, Your Lordship.
What money?
The excess money was returned back to retail, Your Lordship. The excess money, page 213, Your Lordship.
Page 1?
228.
128.
228. And extra 11. May I read, Your Lordship?
This is dated. What is the date of this? Oh, this is on the top. 15/5, 2018.
15/5/2018.
Now your FIR is dated what?
FIR dated 16/6/2017.
Okay, so after the FIR you have
Yes,
paid.
And Your Lordship, pertinent to mention, Your Lordship, that the
What is SOR items?
Schedules of requirements.
Rates. Schedule of rates.
Schedules of requirements.
So according to you, these settle the entire issue.
Yes, Lordship. And it's pertinent to mention, Your Lordship, that the work was completed, Your Lordship. A certificate was issued, Your Lordship.
Where is that?
Annexure 19, Your Lordship. Page 325.
This in 2021.
Yes, yes, Your Lordship.
What is the date of charge sheet?
Sixteen 2017.
No, that is FIR.
The
Charge sheet is
same.
26,980.
Your Lordship, if we come to Annexure 16, Your Lordship, the charge sheet is dated 16/6/2017.
Annexure page.
Next, 246 is the charge sheet.
There's a FIR number, date of the FIR 16/6/17.
See, this is final report charge sheet is blank. That
SCL
is
number 3, my lord, 26,980.
yes, 26/9.
26,980.
The earlier date is with regard. This is FIR.
FIR date.
Yes.
Your Lordship, you can see that in the certificate, Your Lordship, it's clearly stated, Your Lordship, that the performance of the agency is satisfactory, Your Lordship. The work continued, Your Lordship, right from the beginning till the end, Your Lordship. There was no complaint or objection.
This completion certificate was page. It was
325.
325.
Annexure 19, Your Lordship.
Okay. Yes.
Your Lordship, we can see that right from the beginning, Your Lordship, the work of the contractor continued, Your Lordship. There was no objection nor any complaint, Your Lordship, from the retail, Your Lordship.
Then what was the basis of that FIR then? How CBI came to register the FIR?
Your Lordship, is for them to explain, Your Lordship. And since the FIR is an...
So according to you, there existed no complaint against you, either from the side of the department or from any other side. Now CBI came to register this complaint of their own, without any basis. Yes.
The allegation raised by the CBI Lordship, in spite the performance of the petitioner is satisfactory, Lordship.
In spite of the fact that you paid those access
Yes,
payment,
Your
repaid the access payment, that you have completed your work. In spite of there being any grievance, this FIR has been filed without. It's totally baseless. That is what you want to say.
Yes, Lordship.
Yes. Anything more?
Your Lordship, lastly, Your Lordship, the fact remains, Lordship, that the matter is governed by the terms of the contract between the petitioner and the retail.
That you have said. Then there is arbitration clause and all. So that is what you have said.
That's all, Your Lordship.
Yes, Dr. Mojika.
Yes.
How long will it take?
It takes some time.
So we'll come back after lunch, or
Can you continue Monday only? I'll not take much. Monday I'll.
yes.
Monday.
And we still have 5-10 minutes. At least you can start. Let us see how far we can progress.
Well, I'll just take your lordship to page 256, my lord. Just to clarify one or two facts, my lord.
Now, what about her contention with regard to the jurisdiction of CBI?
Yes, my lord. The legal question I'll answer, but just to clarify two facts, my lord.
Yes, you.
Page 256. So, my lord, 4 persons.
Yes, madam, you sit down.
4 persons were charge sheeted, my lord. Named in the FIR.
256. What is this 256?
It's a part of charge sheet, my lord. Charge sheet starts from 246, my lord.
Okay. Yes, 254. What do you want to show?
256, my lord. Only the one thing I wanted to show, my lord. That 4 persons were named, my lord, in the FIR. Number 1, my lord, his name was Sanbor Kharkongar. He was joint general manager of.
Which part you were?
I'm referring to page 256, my lord. First para.
Yes.
From the end, my lord, 4 lines, my lord. The sentence starts due to.
Yes.
Due to lack of sufficient evidence of direct involvement, conspiracy and quid pro quo could not be recollected against Sri Sanborlang Kharkongar, Joint General Manager. Therefore, no criminal action is being proposed against him. However, for the lapses on his part, departmental action against him is being recommended to his department. So that was accused number 1, my lord, in the FIR. Next, my lord.
Yes.
There will be next parameter. That during the investigation, it has been revealed that Sri Subrato Bhaumik, Manager, Railtel Corporation Media, Shillong, has also played important role as he has signed the said MBs. the measurement books, my lord, MPs, and other relevant records when no such chase cutting had been executed at sites, amounts to abuse of his official power position which he had done dishonestly. However, he has expired during the investigation and hence no charge sheet is being filed against him. He was A2, my lord. So, my lord, why I am pointing out, because this will address to some extent the presence of...
The fact remains that charges under PC Act were dropped.
Yes, my lord.
So that is what.
Well. Now, with regard to allegation of conspiracy, my lord, the previous page 254, my lord. I'll answer these two questions, then I'll come to the legal question.
Yes.
The third, during investigation, the para starts from there, my lord. It is revealed that the accused officers, late Subrata Bhaumik, A2, senior manager, and Sri Kutbollang Kurba, A3, project engineer, outsourced of Railtail in connivance with the contractor. Contractor is the petitioner, my lord. Fraudulently and dishonestly had shown to have done chase cutting in 93 so-and-so kilometer in respect of 54 villages in the measurement sheets, summary sheets, and also in the measurement books and site registers. Investigation revealed that as per conspiracy, the officials of the rail tail made false entries in these registers, and on the basis of these entries, the contractor have prepared and submitted 7 false CC bills amounting to rupees so and so, which is including chase cutting amounting to rupees so and so. As per the contract, 50% of the chase cutting bills amounting to rupees so and so were paid to the contractor. However, during investigation, it has been revealed that contractor was entitled for chase cutting bills amounting to rupees so and so. So basically, the conspiracy angle was established, my lord, between the accused persons, including the contractor, my lord. Now, coming to the jurisdiction of CBI, my lord. The notifications. But this is from CBI. Under these are the offences notified under Section 3 of the Delhi Police Establishment Act. But I'll place the gazette notification because this is from the CBI manual. I'm just placing it for today. On Monday, I'll try to place it from the gazette notification.
No, but then what about Section 6? See, this will not cover. This is with regard to Section 3.
Section 3.
So, what about Section 6?
But Section 6 is Lordship is noted, my lord.
No, this notification which was referred.
Yes, my lord. First it says Prevention of Corruption Act, my lord. Then it says any offences page 32.
Page 322, just see page 322.
So this is under Section 6 of the Delhi Police Establishment Act. A is offence under Prevention of Corruption Act.
Yes.
And then B, attempts, abatements and conspiracies.
Yes.
In relation to or in connection with one or more of the offences mentioned above, and any other offence or offences committed in the course of the same transaction arising out of the same facts.
So that any other, according to you, would mean
will cover
offences under IPC also.
This will bring in Section 6 notification, my lord.
Yes, it has basically The sentence
Yes, my lord.
that which says there's any other offence or offences,
From the same transaction.
that will take care of the situation. Okay.
The other aspect, my lord, that has been contended, that while at the time of filing a FIR, there were public servants involved, my lord. But once their names have been dropped,
Now, what about
Of this prevention of-
the decision of the coordinate bench with regard to that?
my lord, in my humble
Paragraph
submission,
25, 26.
in my humble submission, that does not have any precedential value now because
No, but then you see, like that those reasoning also, which way you overturn, which way you say these are not good reasons,
Supreme Court said the question of law
remains open.
Remains open, my lord.
Definitely.
It is open now. So we have to argue afresh on that point, my lord.
Definitely, we'll argue on afresh. I'm not saying that that will be binding, but the Supreme Court has not also not set aside that finding. That finding remains.
Yes.
Okay. If you go by the apex court order, what the understanding will be that the finding recorded there is not conclusive.
Yes.
It is
It
open
is
for argument.
open for argument now also.
But then that part has not been set aside also. So if you do not find any other version, convincing
Yes,
version,
yes.
we can go by that also. There is no bar for the court.
Yes.
So that is where we
So I'll try to convince the honorable
the
court of that.
reasoning which
Yes.
was pointed out by
Yes.
the learned counsel.
I will argue afresh on that point, my lord. That point is open now for us to argue.
No, that is where you have to point out.
Yes.
And the aspect that you see, like the initially when this investigation started, apparently the case was registered under prevention of corruption. Now, at the end of the investigation, it is found that there exists no charging is PC Act, and the charge sheet is filed only under IPC. Then whether the investigation or the legality of the investigation of CBI can be challenged.
My lord, there are decisions on that. I'll place on Monday.
Just try, just place it on this part.
Because there are many
Whether-
cases.
whether
I came
just
across cases.
because-
My lord, the case started with PC Act, my lord. Subsequently, PC Act was
No, even if you find that this notification basically goes in their favor, then in such a case, if you can show us that yes, any investigation which started under Prevention of Corruption Act, but that ended up in it.
Even if PC Act is not continued, my lord, the charge sheet will sustain, my lord, by CBI.
That is something.
I'll place. I've come across judgment, my lord. I'll place.
Heard Lorry counsel for the petitioner at some length. List again on 27th. For further hearing. See, madam, if you find some more law on that point, that aspect, the jurisdiction of CBI, apart from what you have given, if there is any other decision in this regard by any other High Court or by Supreme Court, just try to find out. Yes. How many more matters are there? 2 more matters are there. Yes.
If I may brief, indulgence. Item 20, Lordship. Item 20, Lordship.
Item?
20, Lordship.
20. Say
Lordship.
loudly, see.
I apologize, Lordship.
What is item 20?
This 528 application, Your Lordship.
Just a minute. And what else is remaining then?
My supplementary is one matter, my lord.
Oh, there is a yes, motion matter, supplementaries. I think the council is appearing through VC. Yes. Yes. How long you are likely to take, madam?
My lords, I'll take 20-25 minutes.
So then we'll come back after lunch. Well, we'll come back after lunch break. Yes. 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 Yes.
Yes. My lords, I am for the petitioner in this. This
Yes.
is a matter where order of discharge has been challenged under section 482 of CRPC 528 BNSS. My lords, this is a matter where the main allegation against the petitioners, there are three petitioners, my lords. The main allegation against the petitioners is that they dishonestly induced borrowers and disbursed amount on the basis of false stock statement. Now, this is the main thing. Now, I'll take you to what has happened through the documents. My lords, if you can come to page number 50. Now, this is an investigation report by Chief Vigilance Officer.
Okay.
If my lords can come at page 51, just the next page, my lords,
Yes.
there is a table made. It says common guarantor for multiple loans.
Yes.
There's Mr. So and so, guarantor for 23 accounts, Mr. So and Mr. So and so. There are many accounts named. Second para, my lords.
These are all
These
petitioners. These are petitioners.
No, these are not the petitioners.
Yes.
Number one is the petitioner, and there's petitioner number one, Mr. Eddingson.
Yes.
And then third line, Mr. Hanbor.
Yes.
He's petitioner number two.
Okay.
Second para, my lords, these businessmen are the actual beneficiaries of the loan amount. They were accommodated by the bank officials. Some of them have accepted the fact that they have given written communication with commitment to repay. Net worth of the guarantors were not assessed during the sanction. Amount of loan far exceeds the net worth of the guarantors. These persons have taken loan in their own name also. All the loans have turned NPA, causing extraordinary loss to the bank, which has occurred due to the malified, reckless performance of duties on the part of the sanctioning authority. All these loan accounts were sanctioned by then branch manager Mr. Kirshan Rimpai. He is the accused number one, my lords. We are not representing him. Negligence on the part of recommending officials is prima facie observed. Case of misappropriation and criminal breach of trust on the part of sanctioning authority.
Yes.
My lords, if you can come to page number 55, which is an internal advisory committee report.
Yes.
Now, this is an internal advisory committee report which was submitted by the general manager of MRB, Meghalaya Rural Bank,
Yes.
about irregularities in UDA branch. Now, my lords, if you will come to page 117, because that's where the allegations against these people are there. Page 117.
Yes.
It says, Dear Madam, loans and advances, defaults under other case involved. There are three tables, my lords. The first table involved by Shri Tinge Singh. That's petitioner number 3, my lords. It says total number of accounts, 15 numbers. Amount is 19 crore 4,12,000 rupees, and outstanding is this much. Similarly, the next one is involved by Shri Hanbor, who is petitioner number 2. And the third is Shri Eddingson, which is petitioner number 1.
Yes.
Now, if you can come to page number 142, which is the complaint, because after this complaint, FIR was registered.
100.
142, my lords.
Yes.
This is 22nd of November 2018 document. Here it says irregularity in UDA branch. My lords, if I can read the third para, brief details are as under number 2.
Yes.
Branch account source reference. The NPA levels of UDA branch was continuously increasing. Management had posted additional officials with instructions to contact each and every NPA borrower for recovery of loan amount. In the recovery process, branch officials noticed and recorded serious irregularities. These were reported to general manager, who in turn reported the matter to the bank chairman. Immediately detailed investigation was ordered in the affairs of the branch. Amount involved in so and so.
Yes.
My lords, here nothing is with respect to us.
Yes.
It only states about the irregularities in UDA branch. Now, my lords, if you will come to page number 145, which is the FIR. Now, on the basis of that complaint, an FIR is registered on 27th of March 2019. Now, if you can see the sections are 120B, 420 and 409, and then Prevention of Corruption Act is also there.
Where is that mentioned?
My lords, at page 145 itself, if you will see number 1, IPC, section 120, read with 420 and 409. Then, my lords, second is PC Act 1988,
Yes.
13.2, read with 13.1D.
Yes.
Uh, Page 146, the names are mentioned. Accused number 2 is Eddingson, who is petitioner number 1 herein. Then accused number 5 is Hornbor, who is petitioner number 2 herein.
Yes.
And accused number 9, who is petitioner number 3 herein.
Yes.
Now, my lords, if you will come to page 148.
Yes.
My lords, para 2. The complaint also contains copy of investigation report of Shri So-and-so, Chief Vigilance Officer, Shillong, copies of annexures mentioned in the investigation report, and list of 114 borrower account. These 114 accounts, which are in various facilities amounting to rupees 14.33 crores, were sanctioned and disbursed and subsequently became non-performing asset, as these loans have not been repaid. This has caused wrongful loss to MRB and corresponding wrongful gain to FIR named persons. The aforesaid complaint prima facie discloses offences on the part of Mr. Kirshan Rimpai, then bank manager, accused number 1. UDA branch, MRB, and 8 private persons named in para so and so, under section so and so. That's it, my lords. Nothing has been stated more in the FIR with respect to the petitioners.
Yes.
Now, if we'll come to the chart sheet, which is at page 151.
Yes.
Page 152, my lords. The date of the chart sheet is there, 24th December 2019. Few sections have been added which were not there in the FIR, which is 468, 471, 477A IPC.
Yes.
Now, if you will come to page 179, my lords, this is with respect to my whatever the allegation has been on the petitioners herein.
Yes.
Page 179.
Yes.
My lords, last para, A2 to A9.
Yes.
It says A2 to A9 in criminal conspiracy with A1, who is then bank manager, intentionally and dishonestly defrauded Meghalaya Rural Bank and several gullible borrowers into availing various loans from Meghalaya Rural Bank, UDA branch, for which such borrowers were not rightfully eligible. Now, A2 to A9, in connivance with A1, A10, and A11, all these three are bank officials, cheated such misinformed borrowers, guarantors, and though concealment of facts dishonestly induced them to deliver their signature on loan document, and later also dishonestly induced such borrowers to deliver the disbursed loan amount to them. That is A2 to A9. They got false stock statement. This is the main allegation against the petitioners. They got false stock statement arbitrarily prepared for such borrowers by A1 in order to make such borrowers appear eligible for the sanction of the loans on papers. Second, A2 to A9, along with the gullible borrowers, guarantors, intentionally, fraudulently, and dishonestly hypothecated such non-existent stocks in the hypothecation agreement by themselves, putting their signature and dishonestly inducing the gullible borrowers, guarantors put their signature on the hypothecation agreement. Next para also I'll read, my lords. A2 to A9 had prior knowledge that the stock statements prepared by A1 pertaining to the borrowers brought by them were false, forged, and such stocks had no material existence. But in order to intentionally cheat, defraud the Meghalaya Rural Bank, they used them as genuine on behalf of the gullible borrowers' guarantors. Now, there are basically three allegations against the petitioners. Number one is they got false stock statement. Second is that they got such non-existent stocks in the hypothecation agreement. And third is that they had prior knowledge, my lords. Apart from these three, there is nothing else, but the stock statement has not been annexed in the charge sheet. There is no document which has been said that I actually forged. There is nothing on record which shows that there is actually forgery. If my lords can come to page number 451, my lords.
Yes.
Annexure 9, my lords. This is 7th of September 2019.
Yes.
Now, this is a settlement letter between petitioner number 1 and the bank. They have reached to a settlement agreement where there is a portion of amount which has been agreed to be paid. If I may be allowed to read number 1, the total amount payable as per the list enclosed is rupees 2 crore 83 lakh so and so. The compromise amount at the rate 75% is 2.12 CR. Second point, as a token of acceptance of the compromise settlement, the initial payment of 25% of the settlement amount, that is 53 lakh, will have to be deposited latest by 15 September 2019. Remaining amount will be paid in 18 months, which will be payable in equal monthly installment of rupees so and so.
Yes.
My lord, similarly for A5, it's at page 459. That is petitioner number 2, Mr. Hanbor. Same settlement agreement.
Okay. And yes.
And then at page 461, my lords, it's for accused number 9, petitioner number 3.
These are all part of charge sheet, or these are documents?
No, my lords, we have annexed it. It's not part of charge sheet, my lords. But this is a letter which is pre-charge sheet, my lords.
Yes.
Now, if I would like to state this,
Whether these
that
letters are disputed or not. These letters are
my
disputed.
lords,
And moreover, whether this is only to pay, whether they paid or not is not, we don't know, my lord. They have to clarify that.
that will show in the order, my lords. That
It's
will
not
show in the order. Yes. So 25% of the settlement agreement has been paid by all the petitioners. Whatever their amount had to be, that has been recorded in the impugned order. But I would like to just state one point, that even after the MRB had accepted 75% of the closure amount, CBI has criminalized a civil dispute. My lords, there was an agreement between the bank and the petitioners. They took loan, and it was basically a contract. But what has happened is mere breach of contract has been given a criminal color. My lords, I would like to place a judgment on this point.
Yes.
My lords, the judgment's name is Hriday Ranjan Prasad. It's of 2000.
Yes.
My lords, if you can come to para 15. Para 15.
Yes.
My lords, last page. In determining the question, it has to be kept in mind that the distinction between mere breach of contract and the offence of cheating is a fine one. It depends upon the intention of the accused at the time of inducement, which may be judged by a subsequent conduct, for this subsequent conduct is not the sole test. Mere breach of contract cannot give rise to criminal prosecution for cheating unless fraudulent or dishonest intention is shown right at the beginning of the transaction. That is the time when the offence is said to have been committed. Therefore, it is the intention which is the gist of the offence. To hold a person guilty of cheating, it is necessary to show that he had fraudulent or dishonest intention at the time of making the promise. From his mere failure to keep a promise subsequently, such a culpable intention right at the beginning, that is when he made the promise, cannot be presumed.
Yes.
My lords, if I can come to the impugned order just to show
Yes.
the payment that has been done.
Yes. Where is that?
That's at, my lords, page number 29. The arguments is there. Page
What
29,
order is
my lord.
dated 6/8/2025? Is it?
Yes, 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 my lords. My lords, point number 3, the bullet point number 3.
That page?
Page 29 itself. It says arguments on behalf of accused number A2, A5 and A9. My lords, last line on that page, A2, A5 and A9 have their individual compromise settlement deed dated 7th of September 2019, according to which, as a token of acceptance of the compromise settlement, the initial payment of 25% was to be deposited by each of them by 15 September 2019. Out of the said 25%, A2 has deposited 61 lakh, deposited rupees 15 lakh, and I think A5 has deposited 15 lakh, and A9 has deposited 65 lakh, my lords.
A2 has deposited. It is shown twice.
6 lakhs. Yes, yes, my lords.
61,91,213. Is it correct?
I'll just check from my local councils, my
Anyway,
lords.
it's all right. It's all right. Yes.
Yes.
Yes, actually, she miss typing. This the second one is not 50 lakh is not, but it's 61.
Second, then what about that 15 lakhs 85,000? What is that?
That is a mistake.
So that is not to be read. Is to be
Not,
related.
not to be counted.
Okay.
It's
Yes.
misrecorded by
Yes.
the.
So, my lords, the main allegation against me is that I dishonestly induced the borrowers on the basis of false stock statement. Stock statement has not been produced. There is a compromise settlement deed, and this settlement deed happened before the charge sheet. Yet the charge sheet had my name, and it was given a criminal color. After that, I again wrote a letter to the bank, which is at page number 94, my lords.
Yes.
My lords, I'm so sorry, at Annexure 13, my lords. That is at page number 463.
Four 63.
Yes, my lords. This is a fresh letter wherein the letter has been written by petitioners to the bank asking to repay the amount. So we are not denying that we never took loan. We are still ready to pay, but because it has been given a criminal color, we have to come before this honorable court and take permission and then do this.
Yes.
Now, my lords, if you will come to the impugned order again, the conclusion is at page number 44. I'm so sorry, I'm taking you backwards and forwards, my lords. Page 44, the conclusion starts.
Yes.
And my lords, if you will come to page 45, the last para, A2 to A9.
Yes.
Now it says the allegations made against accused number A2 to A9 is as follows. A2 to A9 in criminal conspiracy with A1, the then bank manager, intentionally and dishonestly defrauded Meghalaya Rural Bank and several gullible borrowers into availing various loans from Meghalaya Rural Bank, Utah branch, for which such borrowers were not rightfully eligible. Now, A2 to A9, in connivance with A1, A10, and A11, cheated such misinformed borrowers, guarantors, and though concealment of fact dishonestly induced them to deliver their signature on loan account, and later also dishonestly induced such borrowers to deliver the disbursed loan amount to them, A2 to A9. They got false stock statement arbitrarily prepared for such borrowers by A1 in order to make such borrowers appear eligible for the sanction of loans, which has not been produced, my lords, ever in the charge sheet. Second point, A2 to A9, along with gullible borrower guarantors, intentionally, fraudulently, and dishonestly hypothecated such non-existent stocks in the hypothecation agreement by themselves putting their signature and dishonestly inducing the gullible borrowers to put their signature. Again, not produced in the charge sheet, my lords. And the third aspect is with respect to prior knowledge. When there is no forged document being produced, the question of prior knowledge does not come into picture at all. My lords, if you will come to the conclusion, next para, perused the materials on record against A2 to A9, the court is of the view 120B is attracted, 420B is attracted. Now, my lords, this is interesting. 409 is not attracted. However, section 403 IPC is attracted. Now, I would like to take you to section 409 and 403. My lords, 409 says, criminal breach of trust by public servant or by banker, merchant or agent. This has not been attracted. 403 says dishonest misappropriation of property. It says whoever dishonestly misappropriates or converts to his own use any movable property shall be punished with imprisonment of either description for a term which may extend to 2 years or fine. My lords, dishonestly comes into the question when those forged documents will be produced. I have a settlement letter with the bank. I have never denied it, so my intention cannot be questioned. I am still ready to pay. Then, my lords, the next section which has been attracted against me is section 468. If I may be allowed to read section 468, my
Yes, please
lords.
go ahead.
468 says forgery for purpose of cheating. Whoever commits forgery, intending that the document or electronic record forged shall be used for the purpose of cheating, shall be punished with imprisonment of either description of a term which may extend to 7 years and shall also be liable to fine. My lords, I would like to give a judgment on this aspect, which is 2009-8 SEC. It's Muhammad Ibrahim.
Yes.
My lords, here if you can come to para number 18.
Yes.
My lords, if I can read para 18. Let us now examine whether the ingredient of an offence of cheating are made out. The essential ingredients of the offence of cheating are as follows. Deception of a person either by making a false or misleading representation or by dishonest concealment or by any other act or omission. Fraudulent or dishonest inducement of that person to either deliver any property or to consent to the retention thereof by any persons or to intentionally induce that person so deceived to do or omit to do anything which he would do or omit if he were so not deceived. Such act or omission causing or is likely to cause damage or harm. Para 19, to constitute an offence under section 420, there should not only be cheating, but as a consequence of such cheating, the
We are
accused should have
not dealing with 468.
My lords, I'm so sorry. It says about
You
467 and
started with
460.
468 and now you are arguing on 420.
Yes, my lords. That's para 17, my lords. Just above.
Yes.
Para 17.
Yes.
When a document is executed by a person claiming a property which is not his, he is not claiming that he is someone else, nor is he claiming that he is authorized by someone else. Therefore, execution of such document is not execution of a false document as defined under 464 of the code. If what is executed is not a false document, there is no forgery. If there is no forgery, then section 467 nor section 471 of the code are attracted.
Yes. Then what relevance this particular paragraph has in this case? It is
My lords,
that,
this
that he
has the
has
relevance.
impersonated, he has signed in.
No. My lords, this comes into relevance only because there are few statements of the guarantors which are saying that yes, the petitioners actually told us to sign here, but there are no complaints by any of the guarantors. And we are not denying that they are not guarantors. This is the only aspect, my lords. My lords, there is one more judgment on section 464. This is Sheila Sebastian. My lords, para 22.
Yes.
My lord, it says, in Muhammad Ibrahim, this court had the occasion to examine forgery of a document purporting to be a valuable security, section 467 IPC, and using a forged document as genuine, section 471 IPC. While considering the basic ingredients of both the offences, this court observed that to attract the offence of forgery as defined under section 463 IPC depends upon the creation of a document as defined under section 464. It is further observed that mere execution of a sale deed by claiming that the property being sold was executant's property did not amount to commission of offence punishable under section 467, 461, 471.
This is a motion matter or final? This is motion matter.
Motion
Not
matter, my
final
lords.
hearing. Not a this okay. All right.
It can be a final hearing today itself.
No, this.
Satisfying. It can be concluded today itself.
All right, yes.
So, my lords, this is what has been held. If you look at the conclusion of the impugned order, there is no application of mind. Whatever the arguments were given regarding the settlement agreement and regarding the other things, nothing is there on record. There is no discussion at all. I can take you through the arguments as well, which is at page number 50. "33, my lords.
Yes.
My lords, it starts at page 38.
Argument.
Yes, arguments. Arguments on behalf of A2, A5, and A9.
It is at
Just
page
wanted to show
that is at
you.
page
Just,
29.
I'm so sorry, 29. I just wanted to show you that the arguments that were placed were not discussed in the conclusion at all. That's it. Nothing else.
All right. Yes. Yes, Mujika.
My lord, from the submissions, what I understand, my lord, primarily they are relying on the settlement. Now, in my understanding, this is a totally misconceived 482 petition, my lord, or 528. If they are in the process of settlement, my lord, they should pay the money and file a compounding application before the trial court. Or if it's not compoundable, they should come by way of 482. That way, my lord, not on these grounds, my lord. That's my short submission in this matter.
Those principle of the Gyanshin case and all those should be.
My lord.
That
So
there is
they
a
should-
settlement, matter has been compromised, it should be.
My lord, that is the correct way. They have only paid 25%. We do not know whether they. Now, if I take your lordship to page, that agreement itself, page 4, it says, my lord, remaining amount will be paid within 18 months. This is agreement of 19, my lord. We are in 25, 6 years, 18 months gone away. Then it says during the period of 18 months, if you fail to pay any 3 installments, then the agreement to compromise settlement will be treated as null and void. The legal proceedings against you will continue undeterred even after settlement of accounts.
No, but then the thing is that the fact remains, if there is any default, will it constitute a criminal offence?
My lord, it is not a simple default, my lord. My lord, I take a car loan, but suppose for example,
Initially there is an allegation by you that there was fraud in obtaining a loan.
Yes.
Then subsequently you enter into compromise. You agree on the amount.
It's bank, my lord. The bank.
See, the manner of payment is chopped off.
Yes.
And then thereafter, if you file that this has not been paid in terms of the compromise, will it be
My lord,
case for
the
criminal
legal proceedings started much before that, my lord. My lord, kindly, I'll just give one example, my lord. If there is a theft, my lord, the person whose item is stolen, my lord, if he gets, he'll be very happy, my lord. But that will not wash away the criminal.
That is also another way of looking at the matter. The settlement, whether to wash off the crime committed.
So, my lord, the settlement can wash off only if they comply with the settlement agreement, my lord, and file a 320 application on the new provision, whatever provision before the trial court. If it is not non-compoundable, that should come by 482 before this honorable court, my lord. But coming this way without even paying, my lord, the story would have been different had they paid under the settlement also. It is an admitted position, only some amount has been paid, and that also 1920.
You can say that a settlement will be complete only
the
event full payment is made.
Whatever has been agreed, 75% of the payment. If they pay, bank is agree, they can come and file a compounding application, my lord.
If offence is compoundable, isn't it?
Or else they can come by way of 482 for washing, my lord, if both parties
But that is totally on the different.
My lord. And in my humble submission, that is the way, that is the correct way. No, not by filing 482 this way,
compromise the basis.
without even fulfilling this compromise agreement, my lord. If that fulfill the compromise agreement, then still your lordship could have given some indulgence to them, my lord.
Okay. We'll pass order.
My lord.
Okay, we'll pass order, man.
My lords, if I can just state one thing more.
Yes.
The settlement letter was prior to the charge sheet filed.
Have you paid
So
the
that
entire
was
amount? Not.
Yes, no, we haven't. It is off record. We are admitting that we have not paid yet because the criminal prosecution continued. That was the reason for not paying this.
There is no stay order on payment, my lord.
No, there is no. But if we get some time from this honorable court, if in a time bound manner, we will pay it. We don't have a problem at all.
Are you agreeable
It's
to
only
that?
with respect to.
Are you agreeable to
My lord,
that?
I am CBI, my lord. Bank, I don't think is a party, my lord. Well, it is for them, bank and them to settle the matter, come to court, my lord, file compounding application.
Then, my lords, if some time may be given, we will.
See, madam,
If some time may,
if you are
yes,
seeking washing of a matter on the basis of a compromise, then probably Dr. Mojika is right. Because that is how matter is settled, and thereafter, after settlement is achieved, then you come for quashing. If compromise is the basis of the argument.
I agree, my lords, but my interim prayer was also stay on the framing of charges. That was the reason. Till the time there is a stay, I can approach the bank and get this done, and then approach the honorable trial court.
Trial will take long
You can
time.
approach the bank at any time.
Trial will
You see,
take a long time.
even if trial proceeds also, that in the midst of the trial also you can compromise the matter. Anyway, that is not the thing. We'll just see to it and pass order. Just send it to my team.
Deeply.